Court calls case People versus Deshaun Glover.
Good morning, Your Honor, and your staff. Attorney Quentin Dox. My P number is 79657. On behalf of my client, Deshaun Glover.
Your name, sir?
Deshaun Glover.
Thank you. All right, what are we doing?
Your Honor, we're going to ask for a preliminary exam at the earliest convenience.
I don't think that that's appropriate at this time. Defense counsel asked me this morning to get media discovery because he only has paper. I informed him of the proper procedure on how to get discovery from our office, but he is not in receipt of that yet. So I don't think it's appropriate to set today.
So all discovery is not complete.
I have the paper, Your Honor. The digital, I do not have.
You do not have the, okay. Have you requested it as of yet or not? That was just a discussion this morning.
Yeah, I did, Your Honor. I did request it to Ms. Pouzon. She informed me.
Okay, how fast is that going to go out then?
My understanding is usually it's the same day.
Same day. Okay, so if he does it today, here's what I'm going to do. I'm not going to set the preliminary examination because discovery is not. Go ahead, sir. What do you want to tell me?
Sir, I just wanted to say I've been in jail for 60 days because we've been trying to receive a discovery. And it's like the more you're journeying and push it.
What do you mean you've been trying to receive it?
Mr. Glover, hold on for a second. Just let the judge do his process first, then we can talk.
What I was going to do is I was just going to adjourn it out 1 week so that all of the information is there. I don't know what.
Your Honor, before we set a date, I do think potentially I should address a bond issue first.
Okay. All right. So I'm going to adjourn it, but I'll let you go ahead. What do you want to tell me?
Your Honor, the defendant has called the victim over 300 times. At this point, he has made comments and had conversations with the victim, including things like instructing her to come to court and not let anybody but the defense attorney know that she's there. And he said, they don't have a good phone number for you for nothing, so you don't even need to bring a phone. Just be there in the crowd of the courtroom and let my lawyer know you're there. This lines up with the fact that Mr. Dox has informed me that the victim was going to be present in order to address the court to say that the allegations are false. At this point, I am very concerned about the nature of these calls. Given that there's 300, I haven't had a chance, over 300, I had a chance to listen to them all. My interns haven't, but there seems to be serious grounds for forfeiture here. So I think in order to ensure that Mr. Glover has due process, as well as that we're proceeding in a allow us to do our due diligence, we need a bit more time.
Okay, and so outside of the other discovery, that information is also going to be provided to defense counsel, the phone calls. And
that is not going to be able to be sent today because it's my understanding he's used over 8 other inmate pins to make these calls. So it's not a matter of me just sending one email to Ms. Doherty at the jail to have them all released. I have to go in and download them each individually and then manually send them over to Mr. Dox.
All right. Counsel, you have anything to say regarding that?
Your Honor, I believe that the complaining witness in this case, as I alluded 2 weeks before, has been trying to call my client, Your Honor. She is there not to, on her own volition, Your Honor, just to say to the court, not to talk about the case, but that she is not afraid of my client, Your Honor, that she has not been threatened by my client, and that she would like the no contact order to be released. That is to my understanding. And she is in the courtroom right now.
I think that's my conclusion too.
You think she's here now?
Yes, Your Honor.
There, Kaylee Loveday?
Yeah.
Okay. So normally, and ma'am, is it correct that you're coming down to ask me to lift the no contact?
Yeah.
All right. So here's the way I'm going to handle it, because normally what I would do is I would hear from her, be assured myself that it would be proper to do so. The problem now that I have in this case is that the people have indicated these 300 calls in which the defendant is not to be having contact with her at all whatsoever. But these 300 calls lead the court and the prosecutor's been frank, she can't get through them all, but it's leading the court to believe that there's some manipulation by the defendant regarding this particular criminal proceeding. And so, ma'am, with all due respect, you may or may not be involved in it. I'm not making a determination at this point in time. I'm not going to hear from you today. I'm not changing any of the bond conditions. I'm not changing the bond conditions regarding contact. I am revoking in its entirety the defendant's phone privileges except for communication to counsel. So he should not be talking to anybody from the jail unless it is his attorney. And I've signed that order already. So I'm changing that. The other issue that comes up is she's here today, but I don't know what was said. And by the time we get to preliminary examination, if she's not here, the people rightfully could then proceed by forfeiture. They could also do so, and there may be issues regarding any testimony that she might give if it is inconsistent with other testimony. I'm not going to go through all of that. I will just say this. Sarah, I appreciate what you're saying in terms of it discovery, but it seems to me some of the discovery you're creating yourself, and that has to get over the counsel. So that delay is you.
Yes, sir.
So here's what I'm going to do. So that,
or no?
Yeah, I'll let you talk to me. But
no, Mr. Glover.
You're probably talking
Mr. Glover.
too much.
Yeah, no, Mr. Glover. Go ahead, Your Honor.
All right. So probable cause conference, I will. So, dear goodness, that the one part of the discovery is going to get to counsel probably today. How long, and I'm not going to hold you to the exact thing, but how long will it take to get the phone calls to him, you think?
I will do my best to get it to him in 2 weeks. I don't think that I'm not going to be able to listen to them in 2 weeks' time. I can say that for certain. I'm not sure that I need to listen to them all, but I think assuredly I can get them to him in 2 weeks.
Got it. Okay. So given all of that, then I'm going to set comes out in 2 weeks.
Your Honor, can I?
Counsel, would you?
No, Mr. Glover.
Yeah.
One more time. You have a chance.
I just don't want to go to court. I just don't want to be pushed back so far. I'm trying to.
You know what? I don't want it to either.
Yes, sir.
But you've also got an attorney that's got to do his job. Your behavior, if true, is making it infinitely more difficult for him to do that.
Yes, sir.
If you stop doing what you're doing, there is not a doubt in my mind that your attorney would be ready to go.
Yes, sir.
So don't be complaining that you don't want anything pushed back. Don't be complaining about any of that. Stop doing what you're doing.
Yes, sir.
Counsel, if those come out in 2 weeks, so just so that they at least get to you and you can look at them, and then we can certainly go from there. Then the next date I have for a probable cause conference after that is the 26th. Are you available?
Yes, Your Honor.
The day after Christmas? Would you be able to do that, sir?
Yes, sir. I'll be via Zoom, but I'll be out of town, but I can do it. Yes.
Okay. Now, adjourn the probable cause conference to December 26, 2024, 9 a.m. Defendant's bond will continue. The changes, all of his phone privileges are revoked. Thank you.
Thank you.